Hi, good evening, everyone, and welcome to another edition of our Justice and Pieces guest speaker series. Today's guest does a lot of civil litigation, a little bit of business law, real estate law, but primarily focused in consumer protection. And we're going to talk about some hot areas there. So thank you so much, Rocco, for joining us here today. And perhaps maybe you can tell us a little bit more about yourself and kind of your practice. And thanks again for joining us.
Thank you, John Paul. It's a pleasure to be here, and thank you for inviting me. I'm a lawyer, as you said. I do consumer protection litigation primarily, involving the wedding industry lately, and also the moving industry, and then a little bit of just business, corporations, um, business contracts. They can even be commercial leases, and that overlaps with my real estate practice, doing just closings and stuff like that. Did you want more of a background of what I did before before I became a lawyer?
Yeah, sure. Let's maybe tell, because some of the students are obviously interested in that transition. So
Yeah.
perhaps maybe you can tell us a little bit about before you came into law and what brought you into law as well.
So, what brought me into law? I actually did not know what I wanted to do when I was a student in undergrad. I was a philosophy student at the time, and I thought maybe I wanted to be an academic and mainly just write books and write articles. But I found that there wasn't really much of a future there. It's an ultra competitive field, and there really wasn't a market for more philosophers. So it really was a matter of like practice, saying, "Oh, it's practical to go into law, so I'll try that." I had no idea what I was going into. I didn't know the first thing about like factum or what a case was. I didn't know anything. Um, but so I ended up applying to law school. I went to Osgoode Hall. Um, I started in 2015, graduated 2018. Uh, During my time in law school, those are good years. I spent a lot of time engaging with other students, starting up clubs, um, learning about learning how to network, learning all the soft skills that lawyers have. Um, and we can go more into advice about how to succeed in law school or paralegal school if you're interested in that. Um, so then I got called to the bar in 2019 after doing my articling at the region of Peel. So I got a varied experience there, doing a little bit of litigation, a little bit of land use and planning, real estate, a little bit of corporate law as well. It was very varied. Um, and then after being called to the bar, I I asked myself, what did I want to do? I knew that I wanted to start my own practice from the beginning of law school, but I was very hesitant to embark upon that because every single lawyer I asked about it pretty much said don't bother, except for lawyers who'd gone and done it. But most lawyers said, you need to get training, you need to work at another firm and have a lawyer teach you everything. But what I learned throughout my articling, and the brief period where I worked as a lawyer for another firm, was that we still do a lot of figuring out on our own. We have to rely on our own resourcefulness and savviness. And I realized that there's probably nothing stopping me from opening a practice except myself. So I said, let's do it. So October 2019, I opened Scocco Law, had no clients, no more income, and I had to rely on family a lot to help me, survive the first few months. But I think that there is a huge legal need out there, and for students who are wondering, if do they want to be entrepreneurial and start up a practice, there's definitely a need out there for legal services, right? And I learned that very quickly. And you know, 20 it was October 2019. Then COVID hit in March of 2020, right as I was starting out. So things were slow, but the real estate market picked up like crazy. So I got some business in real estate, and then June of 2020, I got my first consumer protection case, and that's when I started getting into consumer protection law. It was just a friend of mine. I was out playing golf, and I got a phone call from my friend saying, "Hey, I need you to talk to this guy. He says his stuff's being held ransom, and he says he needs you to help him." I said, "Well, why doesn't he call the police?" Why wouldn't you just call the police? And as I was about to like make a chip onto a nice high green, it was a very huge hill. I remember it vividly. I didn't know how I was going to make that chip, and I'm thinking about, why isn't this guy just calling the cops? Like, why would he want a lawyer to help deal with this? Isn't it a crime to steal people's things? What I learned very quickly is that it's not a crime if there's a contract, and the police don't touch it. So that means that anyone who's a victim of like some kind of moving fraud or moving scam won't be able to go to the police to get anything done, um, except in cases where maybe they've paid the inflated amount and the contract's been fulfilled and there's still more demands. Maybe the police will help you. Um, and then that really led me to where I am today. I just kept pursuing. I started learning more about how it's happening in Canada, how there's two CBC Marketplace documentaries about this phenomenon already. There's articles being published all the time. The Canadian Association of Movers has notices on their website about it. It's something that's very prevalent in Canada, but people don't find out about it until it's their turn to make a move and make a jump. And the companies that tends to be the bad actors tend to also be really good at digital marketing and getting their websites on the first page of Google. So chances are they'll be one of the first people you see, and they have the most tempting quotes, right? And they're extremely friendly when you talk to them. So everything looks good until it's too late.
Hey, Rocker. So there's a lot that I mean, I definitely want to talk about that. But
Yeah.
since you did mention, I always, for anyone that went to Osgood, always nice to speak to fellow alums here. Now, you mentioned you being involved in clubs, and what was the law school like experience? And I think let's go from there, and then we'll come back and work our way to consumer protection, because I think there's a lot there. That, I mean, I didn't know if there's a contract that it basically is like a license to just do whatever and jack up the prices, and you can't go to the police, so you either pay or you don't get your stuff and try to sue them, and who knows what happens there. So let's go
Yeah.
back to
Yeah.
law school there. What was Osgood like? What were the clubs you were involved in? Actually, I was speaking to some high school students yesterday from my old high school, and they were asking about balance between extracurricular and um, classes. So how did you kind of make all that work?
So when I went to law school, um, I was actually never the most sociable kind of guy. I was more like an introverted kind of guy, and I went to it knowing, okay, I need to become like more social. I need to open up more. I need to get more involved in things. So it was a bit of a concerted effort on my part to try and figure out getting involved in clubs. So um, I got around to that in my second year of law school, where I started a club for Italian students. It's known as CHOW, the Canadian Italian Association. CHOW, Canadian Italian. Uh, Wow, it's been a while. Canadian Italian Association of Osgood. That's what it was. And yeah, we started that one up, and we had Frank Iacobucci come at the end of the year. We just tried to put on like lots of events to try and get students, bring in lawyers, create panels, um, and it was a lot of fun because I was able to meet a lot of other students. It gets your name out there a little bit more because people see that you're organizing things, right? And it was really good bonding. And it's intimidating at first to go and try and start one. I don't know. I was really intimidated. I thought like I was crazy trying to do that, trying to organize and run something. But it's pretty simple. Now balancing that with school, I found that I spent a lot more time doing the club stuff than the school stuff. Um, you know, it was actually it was quite stressful at the time, but you kind of just need to learn where to say no. If you feel like you need to focus more on your school, you need to know when to say no to opportunities, essentially, and just find the time to focus, and rely on your peers for help too. Right? If you're spending a lot of extra time, setting up events for your classmates, talk to your classmates, learn from each other. I think the value of being in school is that you're in a community of learners, and the legal profession, I think it's also a community of learners, at least for the most part. Not every lawyer is going to be friendly and willing to kind of teach you things, but I find a lot of them are, and a lot of the ones that you'll enjoy spending time with will also be happy to just talk about the law with you, and they might point things out that you never knew. So embracing that in law school will help you get ahead. Third year, I started a club called LEO, the Legal Entrepreneurs Organization, and they're still running as well. And that was an idea I had because I wanted to start a practice, but I didn't know how. So I thought if I created a club about it, then we can learn more about it by bringing in speakers to talk about what it takes to set up a practice or even pursue law in different capacities, because there's also a very flourishing legal technology world out there. And I wanted to embrace that a little bit too and learn about it. I've discovered that technology is not necessarily my favorite thing, but I was interested in it early on. And then I found, okay, maybe that's not my thing. I'm more on the entrepreneur, just creating a practice.
Now, now I know. I think your summer student actually came and spoke with me a couple times actually, and so I think one of the things that he brought forth and that you shared here is the importance of connecting, and they organize through an organization called Legally Bright a lot of mentorship for prospective law students. So maybe now you can give a different perspective in terms of mentorship. Now you were talking about the legal community being very collegial and friendly, the importance for students to kind of network with lawyers and paralegals and so forth to kind of get the insight there of what it's like to practice.
Right. And I see a comment in the chat was like, what was the most important thing you found built your practice? And it's other people. Lawyers, we're in an economy of people. And I think that selling the service is not the hard part. I think people need the service and they need to know someone they trust who can do it. It's a part of the real issue is how do people know where to find you, or how do people know that you're out there? And that's the part where you have to learn how to network. And I don't think you can be a lawyer with your own practice without a certain amount of networking skills. Like, for example, I haven't had an operating website for the duration of my practice, but we're busier than ever. Like you mentioned, I have a summer student. I recently took on an associate as well, who's amazing. And it's because of the connections you build that push you forwards. I think is more valuable than just marketing on the internet. But I mean, marketing on the internet is effective too. And I have colleagues who are excelling just focusing on online marketing.
Right. So one of the things there, I think, I don't know, 10 years later at Osgood, how much it changed about kind of focusing on the business of running a practice, right? I mean, I think, you're in a unique situation, within your first year, you're ready to run your own business, right? And I don't think we have always, I mean, even when you start, you certainly, or even while you're in practice, you don't necessarily always have the answers to some of the things the challenges that face you. So what can you share with students who are perhaps thinking about a year from now, 2 years from now, running and opening their own practice, kind of how it worked, and especially during a pandemic, and what are the things you've learned from that experience? What are the things you may do a little bit differently if you could have the chance to do it again?
There's a few things. One thing that I did do right is I had some money in the bank saved up from working. It just is money that I saved up. That money got me through the early months, right? Like, I'm not a big spender, kept my expenses low, and I just kind of hunkered down at the beginning. Another thing is that I wish that I did more of is figure out all the processes and procedures for the practice before taking on like a volume of clients. For example, like practice management software, that's something that you should get right away. I did have one. I wasn't fully competent with it. I didn't know how to fully utilize it. I do recommend a practice management software. I think it's faster and allows you to do a lot of things more quickly. If there's specific questions about practice management software, I could talk about that, but generally get that set up. Figure out what your retainer is going to be. You actually need to have a retainer agreement to retain clients. So give that some thought. Talk to some other lawyers, look for some precedents, and have a retainer before you go out there holding out services. Have like an ID form that you need for clients. The other thing is you're going to have like a lot of fees too. You got to pay your Law Pro fees, which is over $2,000. Your Law Society of Ontario fees, so that's another $2,000 there. And get a website before you start practicing. Don't wait till after, because you might get too busy and you won't have time to build a website. Is there anything else? The other thing to do early on is just tell people what you're doing. Tell your friends. Is there a set amount for a retainer? I see in the comments. It depends on the amount needed for each case. So typically what lawyers do, it is called an evergreen retainer, where you take a deposit of a certain amount of money and you hold it in your trust account, and then you bill your time through that amount. You could otherwise just send a bill to a client and just do the work without any deposit, and you just bill them and expect them to pay. That is a case by case. It depends. The classic lawyer answer. It really depends on how much trust you have in that particular client. Like, do you think that they're honest? Do you think that they're going to pay you, right? Or are they a total stranger? Do you think that they might be kind of sketchy? And I judge the deposit by that amount. And also the other thing is, how much work do you anticipate right away? Like, do you just need to give some independent legal advice on some documents? Or are you conducting a litigation? Are you doing an application? Is it an appeal? Or is it like a real estate transaction? So how much for the retainer? $2,000 if it's something smaller. It can go up to like $5,000 if it's going to take a little bit more time. It could be, $10,000 if you're expecting it's going to be a huge appeal with a lot of research involved. It really depends entirely, and don't lowball your clients. Make it sound like it's going to be more expensive instead of less, and that's not to be greedy. That's to give them a good expectation, and so that they don't hate you when the bill goes higher than what they expected and what you told them. They'll be grateful that you overestimated and they're not paying as much as they expected. And because legal work takes a long time. It is, and it's expensive for that reason. It takes a lot of expertise, and there's a lot of non-billable work that you're going to do, like organizing a file. You'll have a folder on your computer, maybe using cloud storage. You got to name all the folders. You got to have them organized in a way that's like logical, right? I agree. Someone should trademark. It depends. I'm seeing in the chat here.
Now, I see a question here about COVID, and kind of you were just starting up during COVID, and in terms of did you build that into the retainer, and how has it changed? I guess maybe if you look at early in 2019 there, what kind of things that you had to deal with that you probably didn't anticipate as a result of COVID in terms of your practice?
So it's ironic. I think COVID's actually made it easier to practice than ever before. I have a work from home setup, and my summer student and associate, they have a work from home setup as well. So I don't carry a lot of office space. I'm able to conduct client intake meetings virtually, ID them remotely. You get a copy of their ID. You get a photo of it before you meet them. Then when you meet them, you get them to show you the ID again. Then you can do an effective identification. You can sign documents electronically. You can even witness document signing electronically now. You can use a platform like Zoom, like we're on right now, and have someone, you send them a link to sign, you have a screen share, and you can see them clicking the buttons and signing. That's witnessing. And the legislature has changed the rules to allow for this because of COVID. So it's made it possible to get more done. Because think about it, you don't drive to the office anymore. Your clients don't have to drive to your office anymore. You don't have to print out documents or sign them and deal with paper jams or with your printer running out of ink. Everything can be run completely electronic, and you can actually be much more efficient for that reason. The other thing is also court hearings are virtual too, which it has its good and bad. The good is, again, you don't have to drive to the courthouse, and you don't have to plan the time to do that. Time that could be used for billing. You just sit in your regular workspace, and you get dressed up in a suit like I am now. I was just in court earlier today, and you just you do it in front of the computer. The challenge is sometimes you have technical difficulties, um, and actually some of the challenges due to COVID and due to not having meetings in person is not everybody is up to speed on the technology. Sometimes you get clients who aren't good with a cell phone, so they have trouble sending electronic documents, for example, or sending photos. It's happened to me. Like, I'm not making it up. Um, or clients have trouble with the video software. So you have to make concessions, and you have to try and help them, and you got to be savvy enough to maybe explain it to them from time to time. But overall, COVID's made it easier to practice law. And I hate saying anything positive about COVID, but it has had that effect.
Now, has there, I guess someone's asking about the time periods for civil matters. I mean, I don't know what
Oh, yeah.
specific, I mean, obviously, but I mean, obviously different regions as well, but how have you found things are sort of backlogged right now, or are they kind of pushing through?
They're still pretty backlogged, but there's checks and balances. When it comes to filing civil claims, like issuing a statement of claim, it's actually easier now because you do it electronically. You upload it on the JSO portal. It gets stamped electronically, and it gets sent back to you in an email. And boom, you got your document. You can print it and serve it on somebody personally. So it's good in that respect, but there is a significant backlog. From what I understand, there aren't any trials happening in small claims court. No trials in superior court are happening. So the backlog is mounting, and I don't know how the courts are planning to address it. My hope is that they have a hybrid model where some trials can be conducted electronically, where credibility isn't a huge issue, right? There are some cases where credibility is a significant issue, and I think you need the the presence of being in a courtroom to assess that credibility of a witness. Whereas if that's not as much of an issue, or if the case is mostly document based and parties are relying more on documents, it could potentially be done electronically. I don't want to say it's impossible. There are challenges with electronic hearings, though. Like if you're examining somebody um, uh, virtually, there could be someone behind the screen, behind the monitor, telling them what to say, holding up a sign. But I mean, presumably you'd notice someone looking up and like trying to read something. But in any case, there's still risk. And I guess to answer the question, yeah, the courts haven't caught up yet. Not the civil courts. I believe criminal courts are still having some in-person hearings, but I'm not really a criminal lawyer, so I don't know too much about it. That's what I hear from colleagues. But yeah, civil courts. But we're hoping to see them open up soon. I think there is hope on the horizon. It's not clear yet, but it looks like we're getting closer to the end. That's my hope.
All right, Rocco. So let's go back to what we started from about the consumer protection and specifically, um, actually, let me take this question here before we move off the Zoom. There, have you ever experienced someone reading off a screen, and how would you address that if they were being coached or they were just reading an email or something?
Yeah, I've never experienced that before. But what I would do is I would pause the person speaking. I would say, I notice it appears like you're looking at something behind the computer. Would you be willing to turn your laptop around and show us the room that you're in? And if they say no, then you ask, well, why not? Well, what would be a good reason to not show that you're not doing something dishonest? You don't want to let an examination go on if you think that there's some fraudulent behavior going on. You want to stop it as soon as possible and address it. Chances are you scare them once, they might not want to do it again, but to be firm and continue calling it out, because they could be prejudicing your client's case significantly if they're getting fed information that they couldn't otherwise come up with or have imagined on their own.
I'm going to pause for a quick second in case there's anything further about Zoom and the electronic era here that we're on in the pandemic, or sort of the more advanced with the electronics there. But seeing on, let's go to the question there, going back to what you mentioned at the outset there about consumer protection. And let's start with the moving company. So why can they just extort you in a sense, or allegedly, let's say, the next word that I need to trademark there, allegedly, right? Why could they allegedly extort you, and you've already paid 2,000, you've agreed, they're going to do the move or whatever the price is, and then they're saying, okay, JP, well, you actually were better off getting your friends and giving them pizza or something to move your stuff to your new place, because if you want your your law school diplomas and stuff to put up on your wall, it's going to cost you another $1,000. Why is that okay?
So it's not okay, but it's not. There's no crime. There's no specific basis that the police can use to go in when because the police officers, they're not judges, so they can't make determinations about facts. They can have some probable cause, but what I've seen happen is the police will show up at the moving company's storage facility, and the moving company will say, "No, they signed a contract. Look, there's a contract right here that they signed. We're allowed to hold this stuff." And the officer says, "Okay, well, what is the officer going to do? Arrest them? They have paperwork. The officer can't decide if that paperwork is fraudulent or not. And further, they would have to send in their fraud unit and do an investigation to find out if there's fraud here. Now, this phenomenon is so prevalent. There is so much going on in Canada that they can't chase down every little mover. And it could be anything from an organized mover to like that's a company, and oftentimes the company that owns several companies. So you'll have like 7 companies that are owned by really the same people, and it's the same like 5 guys running it, but they'll look like they're 5 companies. And I could talk more about that after. Um, but it could be someone on that scale, or it could be literally 2 guys in a truck who one day decide they want to make some fast cash, and they go and throw up a quick website online, fake website. They're so easy to build these days if you're a little bit tech savvy, and you rent a U-Haul or a Hino truck or anything from someone else, and you do a pickup, and then you increase the quote. And oftentimes, when this happens to a consumer, they feel very helpless, right? Think about all of the personal belongings you have that have like significant sentimental value, right? Some collection that you had from when you were a kid, some photos of your loved ones or your family, or maybe you have some medical equipment that they're holding. And I've seen this before, like CPAP machines that people use for breathing. And you're in that moment, and they say, "Pay us now, or we are going to throw your stuff in the trash after 30 days. You decide what you want to do." You go and call the police, and the police say, "This is a civil matter. We can't do anything for you." You make some complaints to the Better Business Bureau and to CAM, but ultimately they can't make them open up their doors. So you've exhausted all these resources. What happens if you don't have enough money to pay a lawyer? Let's say you even get to that point. You're probably just going to pay, because it's not, for a lot of people, it's not worth the fight. And you just kind of want to go back to your regular life, and you just forget about it and move on, or try to forget about it, mind you. So they tend to get away with it. They tend to continue, and they make a lot more money, right, than a normal moving company would, because they can make the price as high as they like whenever they want. And the other thing is they can disappear whenever they want to as well. They shut down the companies, and then they're gone because they'll use the corporate shield to protect themselves. So at the end of the day, the police won't get involved because they determine it's a civil matter. Now, what protections do people have? There's the Consumer Protection Act. The first one that is top of mind is Section 10 of the Consumer Protection Act, which just says if you're given a quote for services or goods, you're entitled to that quote plus 10%. If they exceed 10% above that quote, you have a right to demand the original quote for those services. The only exception to that is if they were relying on information that you gave them, and that information was false or misleading or whatever, right? So like if you didn't give them complete information, like so say a moving company, they come and they do a walkthrough of your house. Let's assume it's a legitimate moving company. They do a walkthrough of your house and they see some boxes, but you don't show them the basement. And in the basement, you've got arcade machines from the 1980s that weigh thousands of pounds. There's a legitimate basis to increase the quote there. But where we're talking about bad actors, they'll just make up the price after the fact. So you have a right to demand it. But that right, in order to enforce it, means you got to go to court. So that's the unfortunate aspect. And there's no police that is a consumer protection police officer. That doesn't exist.
Yeah, it's interesting actually because since we'll remember today they had their contract law. So the contract law exam, we were talking about, past consideration is not good consideration and fresh consideration. So if they did something like moving out arcade machines, and then they'd be entitled to get some more money. But if not, then obviously they're just doing the same work for more price. So what are you getting out of it other than to avoid this battle in court? Who knows what would happen what happens to your stuff? I mean, you're gonna have to pay and hopefully get the money back through the court system somehow, if anything, right? Is that generally what happens, or if you're not able to negotiate something, or what happens when you get the services of Rocco here?
So when a client approaches me and they say, "Help me, my stuff is being held hostage. What do I do? How do I get my stuff back?" First thing I always try and do is try and negotiate, see if there's a way that it can be settled and just have the goods returned for a lower price. And oftentimes, though, people don't want to pay any more money to the company because they're upset and because they view the company as predatory and malicious. And people generally, their moral convictions make them feel like they don't want to pay anything and let them profit. I've heard people say they're just going to get away with it if I pay them. So people don't like that. So what we end up doing instead is we pursue a motion under Rule 44 of the Rules of Civil Procedure, and that is an interim motion for return of personal property. So you can essentially go to court and ask for an order before a final ruling, before judgment, before trial. You can do a motion, and if you prove that there's substantial grounds that you're entitled to possession of that property, the court will make an order that it be returned to you. And if any of you are interested in reading a fresh case on this, there's a case called Gignac and Move Me Again Transportation. This was reported back at the end of April, early May. That was a case that I acted for. I can put it into the chat if your students want to look at it. And this was a motion for interim relief under Rule 44. And let's see, there's a question here. Are you entitled to get compensation for expenses that are incurred while your stuff is held by the company? That's something we claim, but that's something that would be resolved on a final judgment. And to date, I haven't had a case go all the way to a final judgment. However, that's something that we do claim, and I think it is claimable because it's caused by the actions of someone who is dishonest, and they cause you to do things that you wouldn't have otherwise done, right? Like there are people who are traveling from, let's say, Ontario to New Brunswick, let's say, and they have an empty place in New Brunswick that they're expecting to fill with all their stuff. They show up there, you have an empty house, you're sleeping maybe on an air mattress if you have one, eating on lawn chairs and maybe a countertop. And it happens to a lot of young people with young kids. So like I've seen young families with like a 2-year-old or a 1-year-old, and they have to sleep on the floor because they sold their other house, they moved to the new house, but they don't have anything. So they have to spend money to replace things. They have to buy pots and pans. Maybe they buy an air mattress because they didn't have one before. They probably try and buy something as cheap as possible just to survive. And I think that's claimable because they shouldn't have had to pay that. If had the mover been honest, they would have received their property and they wouldn't have to buy anything to accommodate for themselves. But that hasn't been decided in court yet, so that's still pending.
All right, so tell us a little bit more about the Move Me Again case. And I think I got a link to the endorsement here. I believe I'm just double checking it here, but perhaps you can share a little bit more of what happened.
So this was a case, couple moving from Ontario to New Brunswick, very much like that. The particular challenges in this case is that when the company approached them on the day of the move, there was a contract that was signed. Now, what tends to happen is when the company rolls up on your driveway, they will just start getting to work, right? You tell them, okay, yeah, well, here's my things, load them up in the truck. So your truck gets loaded up, and then they say, okay, you got to sign now. And they pull out their agreement, whatever it is, and they say, you need to sign for this. Sometimes they will bully people into signing, and they'll pressure them. That was the case in this decision where there's significant pressure that was put on one of the plaintiffs to sign an initial this contract. And indeed it is duress, right? A police officer can't decide that this contract is duress, but a judge can. So you need a judge to decide and make a determination, is this going to be a valid contract? And in the Gignac case, so when you're doing a Rule 44 motion, no facts are being decided on a final basis, right? It's judges or a masters. In this case, we go before a master. It's their determination of whether there's substantial grounds. Substantial grounds means that based on all the evidence and the facts and the law, is there a highly likely chance that it would be decided in the plaintiff's favor for the recovery of property, right? So you can get a final order of replevin. That's the name of the remedy. Rule 44 is essentially a codified, it's a codification of the replevin remedy, which is just return of personal property. That judge only decides on an interim basis. So he has to decide, is it probably going to be upheld? In this case, it wasn't. It wasn't found that it would be upheld because there was a bit of duress and misinformation, and it was also an unfair practice. So the Consumer Protection Act makes it prohibits unfair practices. And there are several of these enumerated throughout section 14, 15, and 16. 17 states that unfair practices are prohibited. Section 18 lists out several remedies. Among those being you can rescind the agreement. So if those of you studying contract law, you know rescission means that you cancel the agreement, essentially, and put the parties back in the place they were before they signed it. So that's something you can claim. You can claim punitive damages. You can also pierce the corporate veil because you can sue every single person who participated in that unfair practice. Now, what's an example of an unfair practice? The primary one we relied upon in the Gignac case is the holding of someone's property, someone's goods, in order to pressure them into renegotiating a consumer contract. So I've got your stuff, pay me what I want, boom, that's an unfair practice right there. You have a right of rescission. And that was the basis, essentially, for our substantial grounds argument before the judge, and he accepted it.
And I believe you were able to get a couple $1,000s in costs as well there, right? So
yeah, they did end up getting offset by the moving company's costs. We'll see. Submissions perhaps could have been made to address those. They weren't at that time. I was surprised by that decision that anything was awarded to the defendants for their move. My impression was that the master at that time wanted to leave it as a zero sum in case the parties didn't want to continue proceeding. There's zero money transferred either way. nobody pays anything, the goods get returned, right? So our client hired a moving company. I found a reputable company for them. They came and picked everything up. They weighed the goods. There was no actual weight recorded in this case. You'll see they never figured out what the weight was. They just said it's probably this much. No, actually, it's double what we said it was before, right? Um, so yeah, so our client picked up the goods and they just moved on, right? Um, that case is still active though, so I don't want to speak too much into the details, but it's still proceeding forwards. Yeah.
Okay, perfect. Yeah, so I guess that was just the order, the replevin order, right? That to deal with that part, and the rest of the case will still be going forward at some point. So we'll leave on that there. I mean, I want to also talk about the other thing you brought up in terms of consumer protection is with respect to, especially with COVID. I mean, actually, even my sister's was supposed to get married in very soon, I think, but they had to reschedule given we didn't know if only three people or so could join them at the wedding.
Yeah.
So what happens in terms of, I'm sure they were a little worried about all this money they've put down. So what can the venues do, and what can the future couples there, what can they do about if they're being kind of held hostage of their deposits?
It's really a negotiation game. Um, the law is pretty untested in this area. I think lawyers would generally agree on both sides that a judge could rule in several different ways. Our position, I mean, we think actually strongly because of the Consumer Protection Act that um, the best arguments are on the side of the couple because they haven't received a service. Equity, if you wanted to make an equity analysis, um, you have one side that's received a deposit, you have another side that's just given up money and hasn't received anything in return. So equity tries to balance things. So the balance would be the money going back to the party who made a payment. Maybe the service, maybe there's a slight service in terms of administering, planning the wedding, communicating with the client, but that's not the whole deposit. You can't eat the whole deposit on that amount. And then there's potential for punitive damages too, because they are holding your funds and saying you have to either postpone your wedding or you have to host it with less people but still pay full price, or you basically forfeit your deposit and we keep your money and you get nothing. And different wedding venues take different positions. And this area of law is constantly evolving, and I'm seeing the way wedding venues treat these issues is evolving as well. So there's really nothing stable here except, we have Consumer Protection Act with some very strong remedies and laws of equity that are also very strongly in favor of the clients. And I think that's why the businesses are coming to the table and just trying to negotiate and resolve things. And the resolution, it really depends on what your client wants at the end of the day. What do they feel comfortable with? Because we're talking about weddings. It's not like I want to have a sweet 16 birthday party where if you miss it, it's not like the biggest deal in the world, or if it's just a weekend party. It's a wedding. That means a wedding is a point in your life where legally everything changes, right? You're married to somebody. Suddenly you have different sets of rights against your spouse, with your spouse. You want to plan to have a family. So people sometimes, they still want to get married and they don't want to wait. So you have to manage that difficulty as well.
Now, I think Marcel is probably thinking, hey, we had this question the other day about what happens when the contract gets frustrated, and I thought you told us, the losses kind of lie as they lie. Is this a situation with COVID that's it? You should have anticipated, or certainly for those maybe in the later point that if that was an exclusion in the clause or something like that, is there something that the companies can say, well, we started planning, we had to book like some catering or something, and there goes your whole deposit, as you were talking about, or is it something that they can just return the deposit considering they've not really done anything if you're booking a year or so in advance for the wedding?
Yeah, that's an interesting question, right? The Frustrated Contracts Act is definitely another thing we rely on. Um, that applies where you have a contract that was signed before COVID. If you sign a contract after COVID, knowing that it exists, that there's lockdowns, and that there's limitations for people, and you plan a 400-person wedding and you sign up for that. Let's say you signed a contract on March 21st, the day after the lockdown orders happened, and it's for 2021 in the summer. You might not be able to rely on the Frustrated Contracts Act because you were aware that this event could be frustrated, right? It's the Frustrated Contract Act helps, it assists in situations where circumstances beyond the reasonable contemplation of all the parties takes place and makes it impossible to perform, right? If I sign a contract that's impossible to perform, knowing that's impossible to perform, that's a different story, right? It might not actually assist the client in that aspect. The other thing that comes into play is force majeure. That's the some intervening thing that triggers a force majeure clause, and they're not all the same. Every force majeure clause is a little bit different. I've seen many of them, and none of them are identical. What's important about force majeure is you have to be specific enough, right? Because it's seen as I guess I should back up and say what it's used for. Force majeure clauses are used to protect, sometimes it's one of the parties, sometimes it's both, but it's to protect the party should some intervening event take place that makes it impossible to perform the contract. So it has a way of essentially hedging the effect of the Frustrated Contracts Act, because you're essentially contracting out of it and saying, well, if this bad thing happens that makes it impossible to perform, I still get to keep the money, or I'm not liable for any loss that you experienced, right? And they'll list, acts of God, fire, war. It could be some other act of God. It could be a pandemic. But surprisingly enough, not every force majeure clause has a pandemic clause in it. So they don't always say pandemic. And it's a question of, because there's no pandemic stated in that force majeure, will it actually be enforced as a force majeure, right? Because it's a powerful remedy. Think about it. You're contracting out of statute that's designed to protect parties to a contract, and now you have a clause here. Should it really be a matter of saying two words, force majeure, in the contract, and all of a sudden you're exempt from everything, right? So I think the courts have generally said that it has to be specific enough.
Perfect. So, Rocco, thank you so much for taking the time here and joining us. It's great to hear about the Consumer Protection Act and specifically those sections, as well as get started your own practice and kind of your journey there from law school to where you are today, and with the pandemic affecting just the way legal practices are running, and another challenge there. So great to hear from you, and certainly for those who are planning on moving, maybe you want to do a little bit more research there before you just hand over some money. Sometimes things are too good to be true, as Rocco points out, right? That if they're charging you like $500 and everyone else is charging you 2,000, well, there might be a reason for that. So better stay safe there, and pay attention to that. So, Rock, I wonder if you can end here with any final words of advice, right? When you go back and look, a few years ago when you were a student, and I don't know if you could imagine yourself 3 years later running your practice, doing all sorts of consumer protection work, and any advice you have for them and anyone else listening to this in the future. And thanks so much again for joining us.
Thank you so much. It's been a great pleasure speaking to all of you. And I think the best piece of advice that I could give is to just believe in yourself and to not give up. And those are so cliche, but let me tell you, I would never have imagined that I'd be here with a practice where now, I've got an associate working with me. and I've got business coming in, and people actually want to work with me and take advice. Being a student, you feel that your time isn't worth anything because sometimes lawyers will make you work for free if you wanted to get your first 1L summer job, um, and you're still learning the law, and it's all uncertain, and the job market's very competitive, and I'm aware of that too. It's hard to find a law job um, as a paralegal or as a lawyer, but at the end of the day, you have to bet on yourself. You know, you are a unique person with unique strengths and talents, and the fact that you pursued studying the law means that you have some sort of affinity for it. Finding your place in it means really just finding yourself in that world and pursuing it without giving up, because you won't make it if you give up, and you really have no idea where you're going to be. You might think you have a plan, but you have no idea, and it might not work out the way you expected. My career did not go the way I expected it to. I feel that the only thing that made my success was the fact that I was just pursuing, and I was looking for opportunities. So that just means just never give up, and believe that you can do it, because you really can if you want to.
Perfect. So thanks again. Wish you all the best. Certainly, we recently learned that we speaking of sharing costs, there we were using the same office there, but I guess I haven't been
Yeah.
in such a long time, given the pandemic. But thanks to Mr. Pasquale there, I should actually try to reach out to him and get him to join one of these days too. So all the best, Rocco, and everyone. Enjoy your weekend. Certainly, um, the weather is nice. The restrictions are slowly coming down, and all the best to everyone. And thanks for tuning in. And see you next week. Take care.
Thank you so much.
Thanks so much, Rocco.
My pleasure. And I'm available if anyone wants to reach out.